Welcome to this 2TG Common Law Group webinar on causal uncertainty in PI claims. I'm Niazi Fetto, and with Andrew Bershadski, we're going to be speaking to this very complex topic, addressed by a wealth of authority, much of it unclear and contradictory. We intend to inform you on the lie of the land right now, the arguments as we see them for the future, and provide some practical insights. Each of us encounters the issues we're going to be covering in the course of the work we do, particularly our employer's liability and employment practices. Andrew is going to focus on the topic of material contribution. I'm going to start off with an overview and a look at the landscape within which that topic arises. Before I launch in, I should warn that we both have a lot of slides, most of which are quite dense. We're likely to fill the hour, but we're not proposing to go through every slide in detail. They're, of course, yours to keep, and we hope that they'll be useful, but we'll try to be selective in order to keep to time as best we can. It's important, first of all, to locate ourselves within the general framework of all, or at least most, negligence claims. Causation is one of several control mechanisms by which the parameters of liability and negligence are set. The slide shows the 6 which were listed non-exhaustively by the Supreme Court recently in Meadows and Carr. We're dealing here with pure factual causation. Number 4 on the list is the loss or injury, the consequence of the breach. Any study of causation today must involve understanding the difference between divisible and indivisible injuries. The critical distinction is that for divisible injuries, there is a dose-response relationship. They're cumulative. More harm is caused by increased exposure to the relevant cause. The slide gives 3 examples of divisible injuries. Bear in mind pneumoconiosis, as we shall come to Bonington, a pneumoconiosis case, in due course. Deafness is quite a good example. In virtually every noise-induced hearing loss case, we have to separate out the amount of impairment due to noise exposure from that due to age. Indivisible injuries, by contrast, are on or off. Once the injury or condition is triggered, further exposure to the cause makes no difference. Examples include lung cancer and mesothelioma. The law treats the 2 categories of injury differently. And I've summarized on this slide the different treatment insofar as things are tolerably clear, and identifying a major area of lack of clarity, which is going to be Andrew's hunting ground in due course. With an indivisible injury, causation will of course be established if the but-for test is satisfied. Otherwise, pretty much the only thing that can clearly be said today is that for cases which fall within the Fairchild exception, to which we'll come, it will suffice to show that any defendant's breach materially increased the risk of injury. And in that context, materially means more than negligibly, more than de minimis, to use the forbidden Latin. What cannot be clearly pinned down is the significance in law of material contribution in the causation of indivisible injuries, i.e., where a cause has materially contributed to the process whereby such an injury has been caused. Andrew will look at that in detail. With divisible injuries, because they're cumulative, any contribution to the injury, provided it's not negligible, causes something. So, for example, with noise cases, the ENT experts will need to address whether, if there was exposure to tortious levels of noise, that has made a material difference to the claimant's overall hearing deficit, and the defendant will be liable to the extent of that contribution. However, in the context still of divisible injuries, if the court is able to find material contribution, but the evidence and argument is not before it to enable such an apportionment, the defendant will be liable for the full injury or condition suffered. Let me now turn to some background to the concept of material contribution. The phrase material contribution can be found in the reported cases going back to Victorian times, largely in Scottish cases. I've given 3 examples on the slide. The use of the phrase caused or materially contributed to by judges then has excited lawyers on both sides looking for insights. But the way in which the phrase is being used is not explained in any of them. And the same goes for the later case of Grant in the second half of the slide. Summers and Cook, cases one from California, the other from Canada, are not strictly material contribution cases, but they are origins of a now famous departure from ordinary but-for causation. So I've included them on this history slide. They deal with what's known as the two huntsman situation, which is an exception, a genuine exception to but-for causation, and to which I will come shortly. Having established that there's little of relevance in the very distant past, we come to the merely distant past, where two House of Lords cases caused a major shake-up whose ripple effect is still very much being felt today. The first was Bonington Castings and Wardlaw, in which the claimant developed pneumoconiosis after having been exposed to silica dust from two sources. The first was a pneumatic hammer at his workplace, and that was non-tortious, and the dust from that was dubbed innocent dust by their lordships. The second source was swing grinders that were not properly kept free of obstruction, and that was tortious, and the dust from those was deemed guilty dust. And the claimant couldn't show that the guilty dust was the most probable cause of the two. And on that basis, the first instance judge held that his claim failed. The House of Lords overturned that decision, holding that the claimant did not need to show that the guilty dust was the most probable cause, but merely that it had made a material contribution to his injury. That was enough for him to recover in full. And Lord Reid, as you can see from the slide, explained that any contribution beyond de minimis was material for those purposes. Now, what's the ratio of Bonington? It's a question that's been debated ever since its decision. For claimants, it's frequently argued that, according to Bonington, it's enough to show material contribution to any injury, divisible or indivisible, to recover in full. There's a difficulty with that, at least one difficulty with that. The House of Lords didn't discuss whether it was dealing with a divisible or indivisible injury at all. And so along with that, no questions of apportionment were raised. Now, pneumoconiosis is in fact a divisible injury. So that was the factual context in any event within which the House of Lords was working. It's also possible to infer from the speeches that the members of the House of Lords might have had in mind that the contribution made by the guilty dust here was necessary for the injury to have occurred. That is to say, in some way, it had but for significance, despite the fact that it wasn't the dominant cause. Lord Keith is perhaps the most clear example of that sort of thinking, as you can see from the quotation on the slide. The pursuer would not have developed pneumoconiosis when he did, and might not have developed it at all, but for the cumulative effect of the two causes together. Lord Reid, not so clear, but not so clear either way. His view was that the combined effect was to cause the disease, the two things together helping to produce the disease, in his words. The other epoch-making case, back in the mists of time, or not quite so far back as Bonington, was McGee, 18 years thereafter. And there the House of Lords dealt with another trickier causation conundrum. In McGee, the claimant contracted dermatitis from contact with brick dust while working for the defendant. The negligence was in not providing proper washing facilities, so the claimant was exposed after work for as long as it took him to get home and wash there. And the problem was that it was unclear on the evidence whether that additional exposure had even made a material contribution to the injury. The most that could be said was that it had materially increased the risk of some injury. Nevertheless, causation was found to have been made out by the House of Lords. Lord Reid again leading the charge. His view, on the top half of the slide, with which Lords Salmon and Simon agreed, was that in cases like this, it's not quite clear precisely what he meant by that, a broader view of causation was necessary, in which, from a broad practical viewpoint, no substantial difference was to be drawn between material increase of the risk of injury and making a material contribution to injury. Notice the heavy overtones of policy-driven decision-making language in the way that he phrased his view. Lord Wilberforce took a different approach, that of reversing the burden of proof. In his view, showing merely a material increase in the risk of injury was simply not enough in any circumstances to prove causation. However, the employer should be liable if it could not prove that the tortious exposure had had no effect. Well, what's become of McGee today? The question's still up for debate, but there's been an awful lot of authoritative comment since the early 1970s. It's a difficult decision, and it has been publicly described as such by the Supreme Court, Baroness Hale saying it is a problematic case. So far as Lord Wilberforce's idea of reversing the burden of proof is concerned, it looks as though that has died a death, having been disapproved in Wiltshire and Fairchild, although the editors of Clark and Lindsell seem to think there is some life left in it. And the case hasn't led to a widespread application of the material increase in risk test as a sufficient test for causation. On the contrary, the test has only really since found a home within the tight confines of the Fairchild enclave. Coming to that, Fairchild was a case, again, where the House of Lords was faced with a very, very difficult causation conundrum. It was, of course, a case of asbestos-induced mesothelioma, an indivisible injury, unlike Bonington and McGee, interestingly, both divisible. There were several defendant employers before the court, all of whom had tortiously exposed the claimants to asbestos. And on the issue of causation, the problem was that the most that could be said of any individual defendant was that the exposure during that employment had increased the risk of mesothelioma. It could not be shown against any individual employer that it had exposed the claimant to the fibre or fibres that had triggered the disease. And in those special circumstances, the House of Lords created an exception, a modified approach to causation, within which it was sufficient merely to show a material increase in the risk. And there were very specific circumstances that circumscribed the territory within which that test could be applied. It has applied within asbestos-caused mesothelioma since Fairchild and has been extended to lung cancer in Hennigan. But it is very tightly confined. I put the conditions at the second bullet point in the slide. And it's arguable that that is or should be treated as the box within which McGee now sits in the modern law. Stepping away from material contribution and material increase in risk for a moment and looking at other territory where the but-for test has been left behind or rejected, we come to the example I referred to briefly earlier of the two huntsmen situation, two huntsmen firing at the same time and the claimant receiving injury or dying as a result. How do you deal with the concurrent causes, the two tortfeasors causing harm concurrently? Modern science being what it is, I rather prefer the polluted stream example. This was referred to by Lord Justice Laws in the case of Ruckman, to which I refer on the slide. If two defendants each pollute a stream with oil, in some instances it may be possible to say that each has interfered to a separate extent with the plaintiff's rights in the water, and to make some division of the damages on that basis. It is not possible if the oil is ignited and burns the plaintiff's barn. So we're dealing here with cases where multiple tortfeasors concurrently cause indivisible injury, and you cannot apportion between them. So there's no but-for causation finding available against either tortfeasor. And in those special circumstances, both or all are jointly and severally liable for the whole. And that's based on pure policy, as set out by Lord Justice Laws in the quotation on the slide. Having mentioned concurrent causes, I feel I ought to mention also successive causes and the cases of Baker and Jobling. These are but-for causation cases. They aren't about uncertainty regarding what harm has been caused by each factor, but rather about how you deal with the second cause in time. And they are completely irreconcilable. In Baker, it was held that where the second cause is tortious, the defendant continues to be liable for the ongoing first injury as though the second had not occurred. In this case, it was the claimant had injured his leg in a road traffic accident for which the defendant was liable and was then unfortunate enough to be involved in a robbery as an innocent bystander. The robbers shot him in the leg and his leg had to be amputated. Nevertheless, although he now had lost that leg, the original defendant was liable for the injury it had originally caused as though it had continued into the future for the rest of the claimant's life, regardless of the amputation, or as though the amputation had never occurred. In Jobling, it was held that a supervening medical condition had a different effect altogether. So where the supervening event is non-tortious, the analysis changes completely. In that case, the claimant had sustained a back injury at work, but later suffered from myelopathy, which completely eliminated his ability to work at all. And it was held that at that point, when the myelopathy became the cause of his unfitness for work, he no longer had the right to recover damages for loss of earnings from the defendant. The House of Lords in Jobling were quite rude about Baker, and I think justifiably so. Now, I know what you are all thinking. Where does Wiltshire fit into all this, since it is also a multiple cause case? Well, I'll tell you. Wiltshire was a case where the tort simply added a further risk factor for a particular injury, in this case, retrolental fibroplasia, or RTF, to a constellation of risk factors that were already present. So negligence was excess oxygen to a premature baby. That was a possible cause, a risk factor for the eye condition, but there were also 4 other possible non-tortious causes, other risk factors at play. And the House of Lords held that this was a but-for causation case and there was no liability. The evidence didn't show that but for the negligence, the condition would not have materialised. The situation is different, at least it's strongly arguable that it's different, where a claimant can show that as a result of the breach, the underlying risk of his or her injury has been more than doubled. So a doubling of the risk may amount, or may be held to amount to but-for causation. There's been some controversy whether doubling the risk works as an argument in practice, but it's now reasonably well established that in the right type of case, for example, cancers caused by exposure to particular substances, you can at least run the argument, and it has some credibility in the authorities, although it needs to be supported by appropriate epidemiological evidence. Lastly, before I pass you on to Andrew, I'm going to take a brief look at causation in the rather specific context of psychiatric injury. There was quite a sharp debate between Baroness Hale and Dame Janet Smith in this area about how psychiatric injuries should be treated as a category. The approach of Baroness Hale, Lady Justice Hale, as she was then, can be seen in the quotation I put on the slide from Hatton. Apportionment is the starting point, she thought, where there are multiple factors, often the case in a psychiatric injury situation, unless, as she put it, the harm is truly indivisible. And notice the word harm there. That in turn came from the approach the Court of Appeal had taken in the earlier, slightly earlier case of Rappon, where the evidence enabled the injury, the psychiatric injury, to be broken down into individual components, individual specific psychiatric conditions, but not fully. And the court endorsed a rough and ready apportionment between the two defendants based on that approximate breakdown. Dame Janet Smith thought that was entirely the wrong way to look at psychiatric injuries, and in Dickinson 02 made her views very clear. She disagreed firmly with the starting point that psychiatric injuries are divisible, or that the harm should be apportioned. Her position was that psychiatric injuries are generally indivisible, and she thought it inappropriate in those circumstances to apportion damages where a material contribution has been shown. You see in the last part of the quote. There should not be any rule that the judge should apportion the damages across the board merely because one non-tortious cause has been in play. Well, both positions have been considered and at some length and in some detail and reconciled by Lord Justice Underhill in BA Systems and Konjac. His view was that Hatton was to be followed, later Justice Hale's approach was to be followed. And interestingly, that the message of Hatton in this context is that psychiatric harm may well be divisible. The may well is a little bit tentative, but that, on a full reading of the case, in my view, signals the starting point for approaching causation in psychiatric injury cases. You start from the position that the injury is divisible, even though, according to medical science, that may be a bit of a tough proposition to support. And what he went on to prescribe was a practice whereby the tribunal or court, depending on your litigation context, should make efforts to find a way to apportion the harm suffered by the claimant between the tortious and non-tortious causes. In his words, however broadly. Only if that cannot be done will compensation be awarded for the injury. And because of that, one of the things that I invariably do in a psychiatric injury case is provide a copy of or quotations from Konjac to my psychiatric expert so that he or she is aware of those principles and is able to, or at least enabled to, consider what the court requires, whatever may be the strictures of psychiatry on the exercise that he or she is performing. Because it does appear in psychiatric injury cases that there is a rule of practice whereby the injury is treated in essence as divisible, even if scientifically it may not be. And what is apportioned, what must be attempted, is an apportionment of the harm done to the claimant by that particular injury, and it needs to be apportioned as between non-tortious and tortious causes, and again between defendants if there is more than one. So it's not a case of material contribution being considered sufficient to establish causation of an indivisible injury, as Dame Janet Smith seemed to be, that seemed to be the way in which she was inclining, but rather it's the other way around. You start on the basis that it's a divisible injury, and there's a safety net for the claimant of liability in full, if and only if that broad brush division proves impossible. That's where I will stop talking. I'll hand over to Andrew without further ado.
Good afternoon, everybody. I'm sure you're dying to hear more about material contribution, and so I'm going to try and add a little bit to what Niazi has said. Before I launch into the detail of what I'm going to talk about, let's just step back for a second to remember what specific type of issue we are dealing with. Say a claimant has suffered an indivisible injury. In perhaps the most straightforward sense, the claimant has died or has suffered a traumatic brain injury or a stroke. The defendant has had some role within the process that has led to that. Say, for example, the claimant has gone into hospital after a period of hours being at home, and there has been a negligent delay in hospital, there already having been a previous delay. And after that entire period of delay, the patient has ended up with a brain injury, say a hypoxic brain injury. The question in this kind of case that's relevant to us is it sufficient where neither party can say what would have happened without the negligent contribution? Is it sufficient for a claimant to say, well, look, you contributed to the process that led to this injury, that much I can say, and therefore I recover? Can a claimant succeed when that is what they are able to establish or not? I'm going to first take you through the 6 cases which I think it is important to know, whichever side of the claimant or defendant fence you are on in the thorny issue that arises in a case like this. The first case, which is often seen as the starting point for the material contribution debate, is the case of Bailey and MOD. The detail of what happened in the case is on the slide. In essence, Mrs. Bailey underwent a procedure for the removal of a gallstone, and there was first a negligent delay of about a day in resuscitating her after that procedure, but also non-negligently and separately, she developed pancreatitis. As a result of both the non-negligent and negligent issues, a few days later, she developed physical weakness to such an extent that she aspirated on some vomit. That led to a cardiac arrest, and she suffered a hypoxic brain injury. At trial, the judge was unable to say whether, but for the negligent delay a few days earlier in resuscitating her, whether she would have avoided her injury. But what the judge did find was that the negligent delay contributed to the overall weakness, which led to the aspiration of the vomit, which led to the cardiac arrest, which led to the hypoxic brain injury. And so the issue was, can the claimant recover when that's what the claimant was able to prove? The claimant succeeded at first instance, the defendant appealed, and the Court of Appeal said that in this kind of situation, there was a relaxation of the but-for test, and a claimant could succeed where all the claimant had shown was that there was a material contribution to the injury. Earlier cases of Wilshire and Hodson were distinguished, as I've set out below. The summary of the position was at paragraph 46 of the Court of Appeal's judgment, a judgment of Lord Justice Waller, and I've set out paragraph 46 there. For many years after Bailey, that was the summary of the law which particularly claimants would quote in a case of this kind. And that established that where you can't say one way or the other whether the injury would have been avoided, you get home as a claimant on the material contribution test. The next important case to come along and deal with this issue is the case of AB and the Ministry of Defence. This was a group action by over 1,000 Army veterans who believed that they had suffered diseases, mainly cancers, as a result of exposure to atomic testing in the 1950s. The issue that came up at trial was one of limitation, and so most of the judgment in the High Court, the Court of Appeal, and indeed the Supreme Court dealt with the issue of knowledge under the Limitation Act, which is obviously irrelevant for our purposes today. But some of the claims turned on whether the court should exercise the Section 33 discretion under the Limitation Act to allow the claims to proceed. The decision in the Court of Appeal was to overturn the decision of the High Court on Section 33. The Court of Appeal found that the claims were so weak on causation that they shouldn't be allowed to proceed under Section 33. And the important paragraph in the judgment of the Court of Appeal is paragraph 150, where it was specifically stated that the material contribution test only applies where the disease or condition is divisible, so that an increased dose of the agent worsens the disease. That, to my mind, is the clearest, most direct statement in the authorities of what the legal position is. What's also important is that this was not an obiter dictum. This was an essential part of the reasoning of the Court of Appeal for why a certain segment of these claims couldn't proceed past Section 33, because the Bailey approach, and Bailey was specifically cited by the claimants because the Bailey material contribution approach couldn't be applied to indivisible injuries. So this is ratio, and it's from the Court of Appeal, and therefore I think very important in this area. There is always a nub, unfortunately, with this issue. Arguably, some of the analysis in paragraph 150 was wrong because it characterised the injury in Bailey as a divisible injury by discussing the injury as the physical weakness in that case, when in fact, that was the process which had led to the injury rather than the injury itself. So this paragraph is not immune from criticism later on. The decision in AB went up to the Supreme Court, but largely on the irrelevant for our purposes issue of Section 14 knowledge. There was very little discussion by the Supreme Court of the issue of material contribution, but I think there was some direct support in the Supreme Court decision of the way the Court of Appeal had approached it, and the reference is there in the slide, paragraph 89 of the decision of Lawlands. The next important decision is the decision of Hennigan, which is an interesting case. This was a lung cancer case caused by asbestos. And what the claimant wanted to do in this case was not just to succeed under the Fairchild principle, but to say that in fact they didn't need to invoke the Fairchild principle because they could get home on material contribution. And the reason for that is, as I'm sure most of us know, after Fairchild, there was the decision in Barker and Chorus, which said that if you fall within the Fairchild exception, damages are then apportioned. So if you as the employer has only exposed the employee to 10% of his or her total dose of asbestos, you only have to pay 10% of the claim. Now, the actual decision was reversed for mesothelioma claims by statute, but that decision wasn't reversed to other types of case, and this was a lung cancer case. So on the face of it, the claimant, who was only able to find 35% of the solvent defendants, or the defendants that they could find were only responsible for about a third of his exposure. The Fairchild exception would mean the estate would only get a third of the damages. So the estate said, well, we don't need the Fairchild extension because we've got material contribution to an indivisible injury, and therefore we get home on the lot. And both the judge at first instance and the Court of Appeal said that you cannot use material contribution in these circumstances. The reason why this isn't necessarily authoritative on the law is because there was a finding by the judge, upheld by the Court of Appeal, that there wasn't the medical evidence to satisfy a contribution on the facts. So they said that from what we know about the causation of lung cancers, you can't actually infer that any particular asbestos fibre has had a role in the triggering of the lung cancer. So strictly speaking, the conclusion of the law was obiter. But paragraph 23 of the judgment of the Court of Appeal seems to say that you cannot prove causation in an indivisible injury case via the mechanism of material contribution. And that is said again at paragraph 46. Again, there is always a nub, and when you read those paragraphs, they could be read as the Court of Appeal simply saying, well, the reason you can't do that is because it's difficult to prove in that kind of case, rather than that it's impossible to do so as a matter of principle. And hence, again, there is a question mark, or a slight question mark, I think, over whether this is a statement of the law necessarily. And that point has been picked up in a later case, as we'll come to see the references there on the slide. The next case that deals with this, that I think you need to know, is the case of Williams and Bermuda. This was a case where the claimant suffered from acute appendicitis and went on to have an appendicectomy. There was a delay in the claimant coming to the appendicectomy, and he suffered various complications as a result. There was both a non-negligent and a negligent component to the delay in the claimant coming to surgery. The case was decided at first instance and on appeal in Bermuda, and so it went up on further appeal to the Privy Council. I should say at this stage that I'm slightly biased in my view on this case, having been junior counsel for the defendant appellant in that case, and the case having not been decided in the manner that I wish it had been. So you must take everything I say about it with a large pinch of salt as a result. The Privy Council said, in essence, that you can apply a material contribution analysis to an indivisible injury, and they seem to say that quite clearly in the judgment of Lord Toulson at paragraph 31. The most important legal analysis was of the earlier case of Bonington, and as Niazi has said, we now know that in fact Bonington was a divisible injury case, but the Privy Council said, well, that wasn't discussed at the time, it wasn't treated as a divisible injury case, and so that's irrelevant. It still stands for the general principle that you can get home on material contribution. And a particular passage from McGee was also relied upon as authority for why material contribution works, which I won't take you through. The conclusion that the Privy Council came to is that material contribution could work in this type of case, but also the Privy Council came to the view that Bailey, in fact, was a but-for case and wasn't a material contribution case at all at paragraph 47. Paragraph 42, of course, the Privy Council found that material contribution could apply. I think that there are a number of problems with the analysis of Williams and Bermuda. Firstly, it is, of course, a Privy Council decision and it is not binding on courts in England and Wales as a result, albeit it is highly persuasive. But there are a number of problems with the decision. The first is that the judgment doesn't deal with AB and MOD, the second case that I talked to you about, which is the most authoritative decision that says that you can't apply material contribution in this case. AB and MOD was relied upon by the appellant defendant in this case, and that authority is simply not dealt with in the judgment. And also, it appears to me that the way that the Privy Council analysed the decision in Bailey, saying that it was a but-for decision, is wrong. It clearly wasn't a but-for decision because the judge couldn't make a finding on a but-for basis in that case. So it is a difficult case in this area. The next case that we come to is a much more recent decision of the High Court, which I think contains a good analysis of the law in this area. This was a case where the deceased arrived with, as it turned out, bacterial meningitis, and there was a delay in the administration of antibiotics. The judge found that had antibiotics been given at the time that they should have been, then the deceased would have survived. So this is a case where the claimant succeeded on but-for causation, and therefore the judge's analysis of material contribution was obiter. However, because the judge had been addressed on material contribution, he went on to analyse the law in this area, I think, very well. The judge set out, firstly, the principles that are clear in this area, which Niazi has already summarised. And at paragraph 201, set out that Fairchild has set up a distinct route to liability in terms of causation. At paragraph 202, the judge reminded himself that it is specifically this question that we're dealing with, whether material contribution can apply to an indivisible injury, that the authorities have not yet answered authoritatively. And he found that the case of Bailey has been contradicted by AB and by Hennigan, and that other cases have restricted the application of the Bonington case to divisible injuries. The judge also looked at the decision in Williams and Bermuda and basically said, well, because Williams and Bermuda actually says that a bunch of previous decisions were simply but-for decisions, then Williams and Bermuda also doesn't take the material contribution argument any further. And at paragraph 209, the judge concluded that orthodox principles apply. You cannot use material contribution to get round the need to surpass the but-for test in an indivisible injury case. And the final case that I'm going to talk to you about is Thorley and Sandwell. This was a case where the claimant basically said that a hospital trust had negligently stopped warfarin for a number of days and that he had suffered a stroke as a result. He said that warfarin had been stopped negligently for a period of 3 days, whereas the trust admitted that only one of those days had been negligent, and the trust said it made no difference anyway. The court found for the defendant on breach of duty, so there was only a 1-day delay, and the claimant failed on a but-for basis. Even if the judge had found that there had been a 3-day negligent delay, the judge found that it wouldn't have made a difference. So the claimant failed on a but-for basis in this case. And so there isn't the uncertainty in this case that there is or was in a case such as Bailey. Therefore, I think what it says on material contribution strictly is obiter. But the judge, again, analysed, and this is a High Court judge, it's Justice Soole, analysed whether you could apply material contribution to an indivisible injury, and he found that the case of AB and MOD, the Atomic Veterans case, was binding Court of Appeal authority, which the High Court was bound to follow, which was against the application of material contribution to an indivisible injury. The judge also thought that Hennigan led in the same direction, and the judge acknowledged at paragraph 151 that this was a legal issue which needs to be fought out at the highest level of court, but at this stage, material contribution cannot apply. So, in summary, on where we are with the law on this issue, Bonington castings, which is probably the earliest main starting point, it's a divisible injury case where the claimant got 100% of his damages, but it was a divisible injury case and now is seen as such. McGee was an indivisible injury case, but is now seen as a very particular instance of the Fairchild exception. Bailey was an indivisible injury case, but has now been seen as a divisible injury case, and therefore its status is unknown. AB, I think, is the clearest authority in this area, which says that you can't get home on material contribution. Hennigan seems to say the same thing, but it has a somewhat perhaps mistaken analysis. Williams is non-binding. It says that you can succeed on material contribution, but it's non-binding and there are problems with its analysis. And the poor High Court judges that had to deal with this entire horlicks of a legal mess, in my view, in the cases of Davis and Thorley very recently, have both come down on the line that you cannot apply material contribution. So this is where we now are, and it's quite obvious that in an issue which is so important, this is an issue which is no doubt going to come back to courts of the highest level where it will be fought out again. The arguments which I think will feature in that debate and which will need to be made, there are a number of arguments for the claimants, and the most important one is that the but-for analysis doesn't make sense in a case where you have much more of a causative agent than you actually need to trigger a disease, because no particular constituent of the causative agent is a but-for cause. Therefore, all you can ever say is that there's been a material contribution in that type of scenario, and that's why it works. And also, claimants can justifiably say, well, if there's uncertainty in this area, the only reason there's uncertainty is because we don't know what would have happened. And the reason we don't know is because of the defendant's breach of duty. So why should the defendant, in essence, benefit from its own breach of duty, so that a claim can never succeed because of uncertainty? So they're the sorts of broad arguments for a claimant in this case. And equally, for the defendant is the argument, well, that's the law. A claim has to prove that a tort has actually caused injury. And if you're not in a position to do that, then why start lowering the test to apply a much lower threshold? That in effect gets rid of the but-for test, which has been a part of our law since time immemorial. And there are very specific scenarios, such as the Fairchild exception and the two tort visas, where two people shoot at you, where there are clear policy reasons to get around that. But material contribution to an indivisible injury would just be a whole-scale abandonment of the but-for test. Is probably the strongest broad argument for a defendant. Clearly an issue that needs to be determined at the highest level. I think some things to be aware of for both sides is that, as in many areas, it's sometimes tempting to get locked into lines of authorities specifically dealing with personal injuries, or specifically dealing perhaps with clinical negligence cases rather than PI more broadly. Causation is, of course, an important element in other areas of the law, in conversion, for example, in insurance cases, and there are lots of observations on very relevant areas in other areas of the law, and I'm sure that once this issue comes up for consideration by the Supreme Court, both sides will need to look at what tests of causation apply in other areas of the law and what can be gleaned from that in the personal injury scenario. One of the important recent decisions in that regard, I think, is the COVID-19 insurance case, where the Supreme Court has found that an insured peril does not need to be necessarily a but-for cause in order to trigger liability under a policy. And the court specifically recognised there that the but-for test can be inadequate in law, and it can be both over-inclusive, it can catch too many causes, but it can also be under-inclusive, where there is too much of a causative agent. So the courts are clearly alive to the possibility of but-for being removed in certain scenarios. There is another principle which is often invoked in claims, which I think needs to be borne in mind by all parties dealing with causal uncertainty. Where there is causal uncertainty, a claimant may say, I touched upon this earlier, that the court should take a sensible and pragmatic view of causation, not get bogged down in the detail and find for a claimant. That line of thinking, I think, goes back to a property damage case called Drake and Harbour, where Lord Toulson said that basically, where a claimant has proven that a defendant has been negligent and the harm which has resulted is the type of thing that you would expect to result from the negligence, then the court ought to make an inference in those circumstances, even where there's uncertainty over how precisely the harm came to be, that liability should be established. So Drake and Harbour itself, it was about a fire. Somebody negligently, an electrician negligently left something in a loft. Nobody knows how the fire started. There was an extra fire. The Court of Appeal said, well, put the two together. That principle has been applied in the clinical negligence context. And I've put a reference from a 2020 Court of Appeal case where, in essence, the deceased suffered a pulmonary embolism in hospital and died. The judge rejected all the actual causal mechanisms that were put forward for how that came to be, but said the claimant doesn't need to prove precisely how it happened. Most of the time, people don't die when they come to hospital with a pulmonary embolism. There was negligence in this case. Most patients would have been fine, and therefore causation was established. And there are a number of cases which have applied that analysis, and that is a line of authority which I think claimants would be well advised to use where there is causal uncertainty, and defendants would be well advised to be aware of where the medical experts struggle to explain precisely how something has arisen or whether it would or would not have arisen but for the tort. So finally, some practical tips from our perspective on dealing with this type of case. Firstly, we think that the weight of authority is just about against material contribution being an applicable test to an indivisible injury case, but only just. Secondly, in practice, we think that material contribution is often something that's raised later on in proceedings by claimants when they feel that they are on sticky ground with their but-for evidence. So it can in fact be a little bit of a double-edged sword. I think that when it's raised in claims, it tends to signal to a defendant that there are difficulties in a primary but-for case, and I have only very rarely seen a claim firmly hang its hat just on material contribution. It's normally an alternative to a primary but-for case. However, there are other lines of authority which are of use to claims in this area, which defendants ought to be aware of, as I've set out. Ultimately, we think that the real focus for both claimants and defendants needs to be on solid but-for evidence, and experts need to be directed primarily on whether or not an injury or an acceleration of an injury or an exacerbation of an injury, whether or not it would have happened or not, on such evidence as there is. And claimants should probably be very wary of bringing a case that relies solely on material contribution. Equally, defendants, I think, should be somewhat wary of simply saying, well, the claimant can't prove his or her case on causation, because there are the two alternative routes, the benevolence principle and material contribution, on which a claimant may still be able to get home on. And ultimately, probably most cases of uncertainty of this type are capable of settlement for all of these reasons. Thank you very much for listening to us in this difficult area.
It only remains for me to add to Andrew's thanks to you for joining us. We hope we've been useful and that the talk's been helpful, and look forward to seeing you at the next seminar. Thank you all for joining us. Goodbye.